Trial lawyers have to introduce documents into evidence at trial. It seems easy, but there are rules that have to be followed, or the document never gets before the jury. Daniel Horowitz is a veteran of over 200 jury trials, and he wrote this video script to outline the basic rules for getting a document, email, text in front of the jury. First, we have the core concept of relevance. Under Evidence Code Section 350, no evidence is admissible unless it is relevant. As defined by Evidence Code Section 210, relevance requires the writing to have any tendency and reason to prove or disprove a disputed fact of consequence. Even if evidence is relevant, Evidence Code Section 352 lets a court exclude the evidence if it overly complicates the trial. The court decides whether the probative value of the evidence is substantially outweighed by concerns of undue consumption of time, confusion of issues, or substantial danger of undue prejudice. Judges will exclude evidence that might send a jury down a rabbit hole and distract them from issues truly relevant to the case. Next, the writing, text, or document has to be authenticated. Evidence Code Section 1401 establishes authentication as a condition preceding admission of the item into evidence. Per Evidence Code Section 1400, you must provide evidence sufficient to sustain a finding that the writing is what you claim it to be. You don't have to prove it 100%. You just have to prove that the item is possibly what you claim it to be. So for a text, you might put on a witness who saw the text on a phone and saw the phone sitting next to the person who you claim sent the text. That is not much, but it would be enough to get the text admitted. Of course, you could do a lot more and prove that the phone actually belonged to the person and that it was password protected. But under Section 1401, only a little bit of evidence is needed to have the text admitted. Statutory methods of authentication are listed in the Evidence Code. Direct testimony under Evidence Code Section 1413 allows admission, based upon testimony from a witness who saw the writing executed. Admissions are a basis under Evidence Code Section 1414. This is when the adverse party has admitted authenticity or acted as if the document is authentic. The reply letter doctrine is under Evidence Code Section 1420. Here, authentication is proven via evidence that the writing was received in response to a communication sent to the purported author. Circumstantial evidence is a broad rule under Evidence Code Section 1421. Here, authentication is based on its content, and that content refers to matters unlikely to be known by anyone other than the claimed author. Regarding documents produced in discovery, the standard is not high. Discovery is the process where the law requires one side to produce documents, texts, or other information to the other side. As noted in the case Hooked Media Group Inc. Apple, Inc., the court's role is simply to determine if there is sufficient evidence for a jury to find the preliminary fact of authenticity. Note, however, that under Seri v. Santa Clara University, mere production does not automatically equal authentication if the producing party lacks personal knowledge of the document's origin. So there is some nuance to this rule. I'm not going to delve into hearsay at this point, but be aware that a document can be admitted, but it may contain statements that are not admissible because they are hearsay. On the other hand, some documents are presumed admissible and accurate. First, there are business records admissible under Evidence Code Section 1271. This statute requires a custodian or qualified witness to establish the writing was made in the regular course of business, at or near the time of the event, and that the method of preparation indicates trustworthiness. A similar rule applies to official records such as police reports. But again, remember that once a police report is admitted, it will contain hearsay, which is usually not admissible unless there is an exception to the basic rule. For digital data, utilize the presumptions in Evidence Code Section 1552 and 1553 apply. Printed representations of computer information or digital images are presumed to be accurate representations of the data they purport to reflect. Be advised that these sections presume the printout is accurate, but they do not presume the underlying information is true or authenticated. Attorneys should be aware of the presence or absence of metadata and also look for prior versions of electronic documents. With these foundational issues in mind, to ensure a clean record during trial, follow this sequence for introducing documentary evidence. First, there is marking. Request that the clerk mark the document for identification. Next, provide a copy to opposing counsel and the court. Hand the exhibit to the witness and ask the questions that establish its foundation. Formally move the exhibit into evidence. These are the basics. Daniel Horowitz is a veteran trial lawyer and has been a law school professor of trial law. If you are a trial lawyer and need assistance, feel free to call Daniel Horowitz at 9252-831863.